Welcome to the Wills and Estate Transmission Podcast, brought to you by De Groots, specialist lawyers in wills and estates.
Hi, and welcome to the podcast channel for degroots.com.au. And we welcome back Max Williams for a discussion today. How are you, Max?
I'm well, thank you, Tony. Good to be back.
Great to hear from you again. And look, we've covered a lot of in-depth different topics, but one that we haven't quite got into is the power of attorney. And this can be very confusing. And we were talking just before, and even I'm not 100% clear on it. So if you can just take us through what it covers and who the benefit is for.
Sure. So a power of attorney, very broadly speaking, is a document wherein you appoint someone else, often known as the attorney, to make decisions and sign documents on your behalf. Now, the specific form that power of attorney can take will vary from state to state because it is largely a document that's a creature of legislation. So each state and jurisdiction has their own legislation that sets out the form that it must take and the specific regulations that apply to it. In New South Wales, we have a power of attorney which relates to your financial decisions, and we also have a document called an appointment of enduring guardian, which covers your personal and medical decisions. However, other states like Queensland, for example, they just have a single power of attorney that applies to both financial and personal health matters.
Okay. So there are different types of power of attorney as well. So if you can just take us through those.
So generally, there are two basic forms of a power of attorney. The first is something called a general power of attorney. This is usually a power of attorney that you make where you appoint someone to make decisions in regards to a specific aspect of your life. It's usually for a specific period of time. And most importantly, if you were to lose capacity, then that document is what we call revoked. It no longer applies. So a common example of where a general power of attorney may be required or relevant is where someone may be going overseas for an extended period of time, but while they're away, there are important documents that need to be signed, such as to do with a conveyance if they're purchasing a property, or there might be certain documents to do with the business that need to be signed. Well, they can appoint someone under that general power of attorney to do that job for them while they're away. So that's the first kind of a general power of attorney.
And will that also be if you're going in a hospital for an operation, for example?
Yeah, it could. I mean, it could be for any reason, as long as you maintain capacity, mental capacity for the duration of that power of attorney. So if you went for that medical operation and things went badly and you were in a coma, well, the general power of attorney is not going to be relevant, which is when the second kind becomes relevant, which is what we call an enduring power of attorney. And just like the name suggests, that power of attorney endures past the point where you may lose capacity. So the general power of attorney, the first one, that will stop if and when you lose capacity. The enduring power of attorney lasts forever, well, until you pass away, basically, or you revoke it. And in that enduring power of attorney, although I suppose you could limit it to specific matters, in practice, the enduring power of attorney usually applies to all aspects of your financial affairs, certainly here in New South Wales.
Great. And you mentioned New South Wales, so let's look at, we are a national company. Are there different rules in different states?
There are, unfortunately. There's a lot of similarity. So general power of attorney is very similar in each jurisdiction. Enduring power of attorney is also very similar. The differences are really, as I said before, around the specific form that is used, the kinds of people that can witness the person making the enduring power of attorney, and the types of decisions it may relate to. So again, in New South Wales, it'll cover financial only, whereas other states like Queensland and Victoria, it can cover other matters such as personal matters or even medical decisions. So it's really got to be careful that you're using the right form for it to be valid. Usually for the enduring power of attorney, in order for that to be valid, the principal's signature, the person who's making the document, they need to have their signature witnessed by a solicitor, a justice of the peace, one of those kinds of qualified people.
Okay. Max, we were talking about power of attorneys and different types of power of attorneys, but who actually do you appoint as an attorney?
Well, there's a number of important considerations. First, and probably the most important, you need to give consideration to the character of the person
Mm,
you're considering appointing. It's no good appointing someone who you don't trust. It's in the name, it's a power of attorney. You are giving someone a lot of power. They can basically do anything that you can do, with a few exceptions. And so, whoever you appoint, they need to be someone that you trust implicitly. Good character, honest, has integrity, all of that kind of thing. So, character is, I think, the most important, but it's not the only thing you need to think about. Um, the next thing you need to consider is their competency. Do they have the skills and knowledge required in order to make good decisions in keeping with the particular types of decisions that they may be making? So, for example, if you're appointing someone as your attorney to make decisions about your finances, well, it's not enough just to appoint someone that you trust. They also need to be good with money.
mm,
You can't appoint someone you trust, but nonetheless is a spendthrift or has no experience with managing large investments. If your personal estate consists of lots of those kinds of things, so I think the competency of the attorney is another important aspect. And then thirdly, I think you need to also consider their capacity. So there's three C's there. So there's character, competency, and lastly, capacity. And by capacity, I mean, are they going to be able to do it? So you might find someone you trust. Yes, they've got the requisite skills and knowledge in order to do a good job. But if they live overseas, for example, in a completely different time zone, are they actually going to be able to do the job properly?
mm.
Because if there's certain decisions that need to be made urgently, or indeed if there's documentation that needs to be signed, having someone on the other side of the world practically is going to pose some issues. Now, legally, there's nothing wrong or there's no problems with you appointing that person, but from a practical perspective, I think that's another thing you need to consider. So,
Mm.
character, competency, and capacity.
And so, how do you go about appointing an attorney?
Well, I think the first thing you should do is see a solicitor because although those prescribed forms for the powers of attorney, which are prepared by the government and they're usually released online, you could, in theory, download it yourself and fill it out yourself and just take it to a JP. But it's not just about form filling. So, for instance, with our powers of attorney that we prepare, we usually have a suite of what are called special conditions that we include or can include that um, address other key issues that a normal off the shelf power of attorney just won't address.
Mm,
So, speaking to a solicitor who has experience with powers of attorney, has seen where things have gone wrong in the past, and can ask you questions to flesh out certain aspects that you might just not otherwise have thought about, I think is really important. So, see a solicitor, they can prepare the form for you, and most importantly, they can also witness it for you.
great. Thank you. Okay, so let's get into the wrap up. So, thank you for that, Max. So, can you please give us a quick wrap up of what we've covered?
Sure. So, a power of attorney is one of the most important documents you will ever sign. And it's a really important document because we don't know if and when we're going to lose capacity. Just like we don't know well, we know we are going to die, but we don't know when we're going to die. And so, with people living longer and longer and longer, the chances of people losing capacity down the track are increasing. And so, having that power of attorney in place is really important for making sure that if that does happen and you lose capacity, there's someone there who can pick up the pieces immediately and keep things going whilst you're not able to. If you don't have a power of attorney, it can create a real headache for your next of kin, because they're going to have to, in most cases, apply to the local state tribunal to have themselves appointed as a financial manager or a guardian, as the case may be. Whereas if you have that document, that gives them the immediate ability to act on your behalf and saves them all that time and money.
Great. And in the next episode, we're going to cover power of attorney disputes, because let's face it, in law, there's always something like that happening.
Looking forward to it. Thanks, Tony. Thanks for listening today. Don't forget to subscribe, and if you require any further information, please go to our website, www.degroots.com.au, and book a consultation. The contents of this podcast do not constitute legal advice and are of a general nature only. Listeners should make their own inquiries about their specific circumstances and seek legal advice.